Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields.
Afternoon everyone, and welcome to Business Legal Lifecycle TV. Today is Wednesday, so it's one of our longer form shows, and we're lucky, or you're lucky enough today to have one of our interview shows where we interview someone so they can share some knowledge with our viewers and listeners. So today is one of those shows. So Jeremy, welcome.
Hi everyone.
Say hello to everyone.
Hi everyone, hope you're having a great day.
Yeah, so we're in July. We're still talking, or we're talking about estate planning and retirement in this month. However, this interview is not necessarily about that topic. The person we did interview is involved in estate type mediations. However, it's not specifically about estate planning and retirement, but we wanted to put it in for today because it's Farley is his name. Share some very important information with Jeremy during the interview, so we thought we'd slot it in for today's episode. So as I said, the interview is with Farley Tolpen. He's the chief executive of a business called the Mediation Experts. So they're alternative dispute resolution organisation with a team of professionals who can help parties resolve conflicts. So Farley is a mediator, obviously, and a lawyer with over 30 years experience mediating, arbitrating and conducting litigation. He's duly qualified, both here in Australia and also in the US, and as a member of the California State Bar, and in Queensland here, the Queensland Law Society. So he's a registered national mediator, a certified family dispute resolution practitioner with over 3,500 mediations to his credit, which seems quite a lot. Farley believes in the real-world efficiencies and effectiveness of mediation and has a 90% success rate in resolving disputes and conflicts. So we've known Farley for quite some time. We've done work with him previously, so we wanted to get him on the show. He does, so as I said, he does commercial, family, workplace, and also estate mediation. So, yep. Jeremy, what were the sort of top 3 takeaways you got from the interview with Farley?
Yeah, thanks, Craig. I think Farley's a really interesting guy. So he started off in America, and we'll go through his history, and as you said before, and he's a really interesting guy. And so we talk about a lot of different topics, but probably the 3 main ones were his thoughts on the 4 agreements, and I won't spoil what that is for the viewers and listeners, but that's really interesting. His process for resolving mediations and why he has such a high success rate. It's really interesting to hear his perspective on the mediation process, and I think that the viewers and listeners will get a lot out of that. And also, what actually constitutes a good mediation. So, how we always try and do practicals, as everyone knows, and I go through preparation for mediation and what Farley can do, and what our listeners can do as well, and viewers, to make sure that they're right and they'll get the most out of the mediation. So, look, this is a really good interview. As you said, it's really on last month in June, but we deliberately wanted to, I tried to get Farley on in June. Our calendar didn't line up, so I really hope that everyone enjoys this interview with Farley Tolpen. Welcome, Farley, to Business Legal Lifecycle TV and our podcast.
Thanks, Jeremy. Thanks for inviting me to your session.
Not a problem. So let's start with a bit about you and your business. Can you give us your history and how you got into alternative dispute resolution?
Sure. There's a good story with this, Jeremy. I've been a lawyer now 33 years.
Wow.
And I'm from San Francisco or the Bay Area, and I had a law firm then, and I had my own practice, and I had associates, but I like to try cases. Right. And in California, mostly civil cases, but some family. But when you tried civil cases in California, you get a jury trial.
Yep.
So even on a breach of contract or anything like that. So I'm in the middle of a 3-week trial, and we're about a week into it. I'm putting my case on. And you call it tea break here. They call it coffee break. The jury goes out. They come back in after the break. The judge says to the bailiff, which is the sheriff, take the jury back to the jury room.
Yep.
Then on his own volition, without any prompting from the defense counsel, he basically ripped my client, called her a liar, and dismissed her case summarily.
Really?
And this guy was known as that. He was known as a cowboy judge. He just did things that were just bizarre. And walked out, and I said, Your Honor, are you sure you want to do this? Yes. Don't you question me. Okay.
Wow.
So I walked out of the courtroom with my client. My client said, What happened? I said, We lost. And she said, Why? I said, I don't know. And then she said, What did you do that caused this? I said, I don't believe I did anything. Because when I did it, as you know, with trials, when you prepare trials, you spend weeks and weeks. You prepare your opening, you prepare your jury instructions, you prepare your witness instructions, your cross, your direct, your redirect, you prepare your evidence, all that. And so that's all your life is.
Yep.
And that's what all my life was. And so when I walked out of there, I went, and I was sitting at home that night having a couple beers. I thought, what am I doing? I don't like this. It's out of my control. I like this mediation model. So this is the mid-90s, and mediation just kicking in California for all kinds of cases. So before you could file any litigation in any kind of case, or any administrative in any kind of case, or any appeal, you had to mediate. Okay. I said, I think I want to do that. So I took a course and started mediating.
Yep.
So I've been mediating probably since 96. So that's how I got into it. I still have my law firm. I still would litigate on occasion, but mostly mediation and some litigation.
Yep. That's an interesting story because, it's something that I always tell my clients is you want to go to mediation and if you can resolve it, you do, because you never know what a judge might do. And that's a great story and a great example of why we say that.
Absolutely. It's out of your control. And that's one of the things I ask at mediation. I wait till it's going to break down until I say that, where do you go from here? Well, we'll go to litigation. Okay. And how much cost, how much time, how much energy, how much negative energy is that going to cost you?
Yeah.
So, can we talk about a commercial decision?
Yep. And that's crucial, isn't it?
Yes.
Yeah.
And the wonderful thing about mediation, and so since I've been in Australia, I mediate full time. It's about almost 9 out of 10 resolve at mediation.
Yep.
So it's great tool. Love it.
That is a great tool. Yeah. And resolving disputes is what we need to save costs and also to clear up a bit of the court system as well, isn't it?
Oh yeah. Because the court system is broken.
Yeah.
It's just, you can't get to trial if you're in the Supreme Court, a couple years at least.
At least, yeah.
Yes, and the district court the same. In family law court, they're setting them now in late 2020.
Really?
Yeah, so you've got to wait over 2 years on a family matter to go to trial. It's just,
Yeah.
And the problem they have is because the judges are overworked, you're not getting decisions out for 6-8 months. So you've gone to trial. And you still got to wait another 6-8 months. That's right.
Yeah. That's right. So the idea of going to trial and people think, oh, great, I'm going to get justice, can come at a massive cost financially, but also from time and stress.
Yes.
Just the waiting process. So,
yes, absolutely. I call that the vortex People are caught in that vortex of living with it day in and day out because it just permeates your life. I mean, this lawsuit is your, yes.
Yeah, absolutely.
And it sounds like you've talked to people about that when
All the
they
time.
come in.
Yeah, all the time we talk to them about that. But before, I want to talk about mediation, but I want to get a bit more of your history. So let's just go back to a bit about how long have you had your own business for, and why did you move into starting your own business, even the law firm way back when?
Well, I had my own law firm for 25 years.
Yep.
And when I went to, in America, before you go to law school, you've got to go to undergraduate school.
Yep.
So I went to night law school then, and I worked for law firms.
Yep.
And I saw how good law firms worked and how not so good ones. I worked for big, small, medium. Yep. And I thought, I'm going to have my own business one day. I know how I can run my firm, because I was starting to learn the procedure and the law and dealing with clients while I was in law school.
Yep.
And I started working for people. I worked for a big firm right out of law school, and I lasted 3 months. I'm not that type person.
Yep.
And then I worked for a medium firm, and I lasted about 6 months, and I said, no, I'm going on my own.
Yep.
So I just said, I want to be on my own because I want to be my own boss.
Yep.
And that's why I started. And I loved it. And I always my father had his own business, so I wanted my own business.
Right.
Yeah.
That makes sense. That makes sense. So obviously you grew up in California, and you started practicing in California. When did you move to Australia?
I grew up in Ohio, but I got out at 18 and moved to California. Yes.
Right, okay. So you grew up in America.
Yes, that's right. That little island east of here.
Yeah,
yes.
that's about 14 hours, that way, or whichever way.
Yeah, that's whichever way, yes.
If you're watching this, it could be that way, it could be that way, it could be that way, wherever it is.
That's right.
So when and why did you move to Australia?
Well, I moved here in September. It'll be 9 years.
Yep.
I moved here because I married an Australian, and she wanted to come home.
Good man.
And I was in Australia in 1988. I thought, I like Australia. I'll go live there. Yeah. Because I'd been through all the big cities, and Brisbane at the time had the Expo.
Yes.
And I liked Brisbane. Mm. And then we came back to see where we wanted to live, because it would go on my wife's job, because I was going to be, excuse me, a lawyer and mediator.
Yep.
They could do that anywhere.
That's right.
And we ended up here.
Yep. And here is Brisbane. We have viewers around Australia, so here is Brisbane.
That's right. Oh yes, Brisbane. Yes.
Yeah. So obviously you've had a lot of experience in the industry, the legal industry and the mediation industry, and now you're running a mediation firm in Brisbane. How do you think that experience has helped you in what you're doing now?
So the experience of having a law firm,
having a law firm, and been doing mediation for the last 20 odd years.
Well, I think the experience has been invaluable to help clients.
Yep.
Because I've litigated many cases. I've represented people in settlement or mediations. I've mediated many cases. I can talk about the law. I can be empathetic. I can be fair. Yep. I can build rapport with the client so I can help them resolve. So I think you get life experiences, because that's one thing they don't teach you in law school. It's how to deal with people and how to talk to people.
Yep.
How to deal with difficult clients.
Mm-hmm.
And not call them what you think they are.
Yeah, absolutely. Yep.
Yes. So I think my law practice, especially my litigation practice, showed me there's a better way to do things.
Yep.
And that's to resolve conflict.
Yep.
As quickly as possible.
And on your terms, and something that you're willing to accept, I think is a great.
It's your turn. It's your agreement.
Yeah.
You have to agree. That means two of them have to agree, or how many parties are involved.
Yeah. They all have to agree. Yeah. So let's talk about mediation. I do want to focus a bit on that. We've talked a little about it already.
Okay.
And can you go through some of the key reasons why people should use mediation as a tool to resolve their disputes, other than what we've talked about already?
Absolutely. One of the key things is, we were talking about the court times now taking years. You can be to mediation, depending on the complexity of the case, within 1 to 3 months.
Yep.
1 to 4 months, depending on what documents need to be disclosed and what have you. So that's time, cost. So The cost is much less, whether you have lawyers or don't have lawyers, and that's up. The client can decide that also. The cost, you're paying for half-day or one-day mediation that hopefully will resolve the matter. So that's your pay. Your costs will be done in 1 to 4 months.
Yep.
You get to make the award.
Yes.
It's your decision. You get to frame it how you want to frame it with the other party. You get to work it out with the other party.
Yep.
The thing about mediation, it can be a great healing process. I'll give you an example. I did a partnership dispute between two business partners, and they had lost communication is what happened. One thought he was working too much and making too much, and the other was slacking off. And the other was the rainmaker and thought he was not doing his job. Then the wives got involved, and it was getting ugly. And this is about a 35-person firm, and it was going to implode because the politics had started.
Yes.
So what happened from there then is that we sat down. So we had a mediation. We spent about 7 hours, but we got it resolved.
Yep.
And one of the keys is the pre-mediation process of my experience, Jeremy.
Yeah, I was going to ask you about that and about what people need to do to prepare for mediation.
Okay. Do you want to talk about the process or the cost?
You talk about both. I think they're both important.
Okay, absolutely. Let's talk about the process. So the process is this. The way I do it and the way I get about that 90% success rate is a lawyer or a client calls me and says, I have a dispute. I would like to mediate. And I get, a brief history and what's going on, what the dispute is, and see how we can get the other party, or if the other party's agreed, or if the court has ordered it, or the lawyers have picked me, whatever it is. And I get the lay of the land from both the lawyers. And then I send out my initial mediation agreement and invoice. And I'll talk about that in a few minutes. But then what I ask in every case that I can, mostly every case, is to have a pre-mediation intake with the clients.
Right.
And so what I do is I talk to your client as an example, and I explain, and it's usually about an hour on the phone.
Yep.
And I explain the mediation process, how we're going to run it that day, what it's going to look like, whether we're going to be together or separate. My role is impartial, but I'm not neutral because I actively facilitate the conversation. We talk about confidentiality. We talk about the time frames. We talk about making agreements. We talk about what kind of agreements we're going to draft. So it takes about 20 minutes for that. Then I'll spend anywhere from a half hour to an hour talking about the history.
Yep.
Okay. So I'll use this partnership dispute as an example. I got the history of each, they knew each other from college. And that's how they started this business, from college.
Wow.
So they did this. Yeah, they've been doing this 18 years. I think they just got tired.
Yep.
And sort of broke apart as any relationship and didn't work on it. And so I find out that, and then I find out what's really going. I try to find out what's really going on.
Yep.
What's driving this matter? Okay. And then I find out, I build my rapport with that client and have a conversation.
Yep.
So Jeremy, tell me what that was like, as an example, or, give me a story.
Yep.
Tell me, and because I want to hear, and then I'll ask questions.
Yep.
And I want to make sure, and I'll ask you several times at the end, have you told me everything you think I need to know to help resolve this matter? Is there anything else? Okay. And then at the very end, we do two things. We delineate issues we need to resolve, and we then talk about date, time, and place for mediation. And then I do the same thing with the other party.
Yep.
And if they're represented by lawyers, I would say it's your client. I would go back and talk to you.
Can I ask a question there? Do you ever get to the point where you think that the parties can't resolve a dispute after those conversations?
Rarely.
Rarely. Okay.
Yeah, rarely. Because usually by the time they've decided to come to mediation, unless they're ordered by the court and it's perfunctory, or I don't think they're capable,
Yep.
That rarely happens in my experience, say in the last 2 years.
Yep.
Yeah.
Yeah, that's cool.
And if it does, if I see it and I don't think it's worth their time or effort, I'll say, now let's not go forward.
Yep. Fair enough.
Okay. And so then what we do is we set the day of the mediation. Excuse me. So these two partners, let's say they had lawyers. They didn't have lawyers.
Right.
But if they had lawyers or if they didn't have lawyers, I meet with each of them for a half hour.
Yep.
And I find out how they're doing. Are they nervous? What's going on since we had our telephone intake? Anything I need to know? And then we talk about the issues they want to talk about. And so they have an outline to read at the mediation.
Right. Yep.
Okay. And then I get them in a group and we start and we go through the mediation, how it's going to run that day.
Yep.
And then we have each of them make a bullet point outline opening of the issues, the general issues they want to talk about.
Right. Yep.
And where the real magic happens, Jeremy, is that we make an agenda from those issues.
Yep.
So, for example, for these two partners, how will we communicate in the future? And we broke it down. How will we regularly communicate? What if we have an issue? What if the other is not listening? So we broke it down in subcategories.
Right.
And then we had a couple other issues. How much time will we each spend in the business? How much money will we each bring in the business? Business disputes. And so we had probably about 5 or 6 items. And what we do on each one is we give them the opportunity to express why that's an issue. So party A, why is communication an issue that brings you here today? And that party will say ABC and he doesn't communicate or whatever it is.
Yep.
And then I go to the other party and they'll say XYZ and he doesn't communicate or he's bad or he doesn't listen or whatever, okay?
Yep.
And then you ask, well, did you hear him say ABC? I did. What do you think? LMN.
Yep.
So what you do is you get them to slow it down and just hear each other.
Yep.
So I love to use the word fair dinkum process, and it is. So, and most of the time it works because I've gone over now twice with them in the pre-mediation intake and the mediation, the process.
Yes.
Sometimes it gets heated.
Yep.
And then we take private sessions. Now these mediations, yesterday's mediation we started at 8:30 and we ended at 6:30.
Okay. Yep.
So they can be long days.
Yep.
Some today went a half day. I would have thought today would have been a long day, but the parties came to resolve.
As long as the parties come to resolve, they'll be willing to stick around for as long as they need to resolve it.
Yes. And then it's managing them and getting them out of their position to interest. How can we resolve this? What would it take?
Yeah.
What do you think it would take? Sometimes you argue over, I had a mediation where one wanted 2.2 million, the other offered 400,000 to start with.
Yep.
We whittled it down, whittle. Started at 8:30. At 6:30, we're down to 50. 8 o'clock, we were down to 10.
Yep.
8:30, we were down to 5, and nobody wanted to move. So I said, we're all getting tired. The lawyers are getting cranky, and they're, everybody's, I'm leaving. I said, let me try one more thing. So I went to this one client, and I said, and his lawyer, and I said, what if you waive the 5,000 and he pays my extra fees because I was owed about half that for the extra time we spent. He said, okay. And I went in the other room and I said, I've got good news and I've got bad news. So I could sort of joke with this guy. And he said, what's the bad news? Or no, he said, what's the good news? The good news is he's waived 5,000. Well, what's the bad news? He wants you to pay my fees. And he said, I will waive the 5,000 and pay your fees, but you have to negotiate them with me. So I said to him, wait a minute, hold on. You'll waive the 5,000, but you want to mediate with the mediator now over his fees. Is that right? And he laughed. He said, yes. I said, okay. How much do you want to pay me? He said, half. I said, no. And we split it or something. It didn't matter. It got it done. He got a win.
Yeah.
He got a win. We got it done. So you try. That's an example. Let's think outside the box and get it resolved.
Yeah.
Because in my mind, you get complex matters, but at the end of the day, it's not a rocket science. And something's usually some stressor drives some negative, frustrated, angry, bitter, sad, grief, whatever it is driving this.
Yeah, I think that's great advice to give people, and it's great to see a process around the mediation and what people actually will see and do if they get into a mediation. And I love the example because I think that gives everyone, the viewers and the listeners, a bit of an idea about what we're talking about. So I wanted to move on, and I had a question in my research when I was going through your articles and everything, and I was very intrigued by the 4 agreements, and I wanted to talk about those and how they work in mediation.
Okay, so the 4 agreements are: be impeccable with your word, don't make assumptions, don't take things personally, and always do your best.
Yep.
So when the first one, and probably the most important thing as a mediator, is don't take it personally.
Yeah.
Even though I think if you're a client that you're absolutely wrong and you're way off base and you're not getting it, it's not it's not about me.
Yes.
It's your agreement and it's your mediation.
Mm.
So one of the things is, and it's very hard as a human when you see things and you just don't think it's fair, but you can't take it personally.
Yep.
Okay. And always do your best speaks for itself. Don't make assumptions is I should not assume anything as a mediator about any part of the process.
Yep.
I just let it be. And because when I start making assumptions, and it's almost, you're starting to make judgments too.
Yes, very true.
And it's not my place to make judgments. It's my place to actively facilitate, make suggestions, but not judgments.
Yes.
And then be impeccable with your word. Just, talk from your heart, talk straight, show the people that you're there to help them resolve the matter.
Yes.
So it's a great, and so, if I can take those in and stay mindful, no matter how difficult a client may be or a situation may be, if I can just keep those in mind, and it's difficult sometimes as a human, not to be incredulous about some things, as you know, as a lawyer.
Yes.
Yeah. It's don't take it personal and let it go. And if you do, well, realize it and let it go.
Sounds good. Well, what we'll do is we'll link to your webpage, the article about that, and also a link to the 4 agreements, the book that's based on. So I think that's excellent advice for people, not only in mediation, but just in life in general. I think I
think so too.
They're great, 4 great pillars that people should actually follow. I think that's excellent.
I think so too. And particularly when we're tired, hungry, frustrated, angry, it's very hard as a human not to be cranky.
That's right.
Ask my wife. She'll tell you.
We'll get her on next time.
Yes, that's right.
So the final topic I just wanted to explore with you, and you've kind of talked about it a little bit, but how do you deal with difficult clients and difficult lawyers? So in the mediation process. So even with an example, you've given us an example of how you resolve one, but dealing with difficult clients and lawyers, what does that look like from your end?
I'll give you an example of a mediation I had the other day, a family mediation, where the gentleman was, I would call, and I'm not a psychologist, but I'd call him a classic narcissist, classic controlling, where he was right. He could not understand how anybody could see that she thought you could think anything else.
Yeah.
And he would get angry if you would ask him, well, have you thought about this? Or are you challenging me? No. So that was the kind of guy I had. And he was very angry and bitter and controlling and right. And they had spent a lot of money, and they were going to spend, if he'd gone to trial, they would have spent the whole pool. And they were fighting over one day a fortnight. Yes. And so what happened was, I found this out in the pre-mediation intake.
Yep.
And what I do with somebody like that is I slow it way down. So I speak much lower like this. I slow myself down
Mm-hmm.
and I give them, there's a method by Bill Eddy that's called EAR, empathy, attention, and respect.
Yeah.
I hear I listen to what he says. There's nobody else. I give him the complete attention. I'm hyper focused.
Yep.
I'm giving him respect.
Yep.
And I'm acknowledging what he says, not agreeing, but acknowledging, even though I may go to myself, oh my God, can he shut up? But that's in my head. Okay.
Yep.
But I'm slowing it down. So I hear that's hard for you. And I hear you want to resolve this today. Is that right? Okay. So can we look at it? How do you think we can do this? This is what she's saying. What do you think? Give them the power or the perceived power. So slow it way down, bring it way down, bring the just calmness down. Because if you try to challenge them, they will arc up and go cranky at you.
Yes.
Accuse you of bias and being unfair and taking her or his side or what have you. So that's a classic difficult client. And it's the same with the angry client. Just let's bring it down. Let's just, okay, I hear that. And sometimes it works and sometimes, you can't. Sometimes they're too angry.
Yep.
It's just, I was in, a family dispute between a father and a son, Italians. And the father kept using the F-bomb. It's like, and nastily, not just, and it's like, I tried to pull him up many times, but it was his only way of getting his frustration out. So the son and I had talked about it, and we had agreed that that was going to happen.
Right.
So we had worked out a plan how to diffuse it. Let him have his, complaints and his, tenseness and his crankiness, and then once he got it out, he could come back to logic.
Yeah.
Till he lost it again, and this went all day. Yeah. Another one for a lawyer was I had a case, and we had a young female lawyer and an old-time lawyer on opposite sides. This old-time lawyer's, thought he was the bee's knees, and probably is. He's probably, he's a great lawyer, but thought she was stupid and didn't know the law.
Right.
Now, her and I had talked about this is what he was going to do. He was going to try to bully her.
Yep.
So he would do things like this. I've been doing this 33 years. I've been doing this when you were in diapers. I know what the law says, and I know what the judge says. And she knew it was coming. And we had planned, I had worked with her in a pre-mediation telephone call that when he does that, just acknowledge it. I thank you. I hear what you're saying. This is where we're coming from.
Yep.
Drove him crazy.
Yeah, I bet.
And I'd have to private session because he couldn't influence her or think he could control it.
Yep.
So that was another one. I think for me as a mediator, it's building the rapport with the individual.
Yeah.
So so it could be the lawyer, the client, or, building it with both. I'm here to help. I'm not here to fight or argue. I'm here to help. And how can I do that? So how do I build my rapport with you as a human? Can I, for you and I know you, Jeremy, I could talk sport with you. Okay.
Right.
We can talk sport most of the time. Okay.
Yeah.
Other people I can be jokey.
Yep.
Other people I have to be empathetic. I've got to be mindful of how I act and that I don't react.
Yep.
I've done, almost 4,000 mediation. I'm still learning.
Yes, absolutely.
Yeah. But it's a wonderful tool. I love it.
Yeah.
It's great.
That's excellent. And that's good advice for people just in dealing with difficult people in general. Don't buy into their nonsense. Empathize with them if you can. And I think that's excellent.
Don't take it personal. Because you know what, it's hard not to if they're like, getting cranky. It's like then you want to get into it. And if you get into it, they're already there. They do both get into it.
That's
it's
right.
Like that.
Yeah. Absolutely. And some people you just can't win. So I think that's great advice for people. So let's move into the topic I always like to talk about with my guests is future. And there's a lot of talk about disruption and changing industries and all the rest of it. Do you see what do you see the biggest challenges are in your industry in, say, the next 5 years?
Well, what's going to happen, what's happening with the court system here, as we spoke at the beginning, it's broken. So coming from California and having been here 9 years, Australia is about 15 years behind California in dispute resolution.
Right.
So what I see happening in this industry is dispute resolution is going to increase because the system cannot handle the amount of litigation.
Yep.
It's just, they're cutting back on courts instead of putting more courts in. So what's going to happen is you're going to have these, people call them ADR, I call them dispute DR processes, dispute resolution processes. So I mediate, but I also arbitrate.
Yep.
I'm trained as an arbitrator. So people are going then to have that opportunity to also arbitrate matters.
Yep.
If maybe mediate first, and if not, then arbitrate.
Yep.
So I think what's going to happen in the next 5 years is that every case before you file, whether it's civil, family, administrative, you're going to have tried a mediation. You're going to have to get a certificate. And you're going to have to legitimately have tried a mediation.
Yeah.
And if you don't try a mediation and you file it, because now, in civil matters, you have to try to settle the matter. Yeah. Well, that's great. Send them a letter. I want $800,000. I'll give you $2. Okay. I tried. Yeah. No, that's not trying. Yeah. So you got to really try. And so that it's going to happen where everything has to be mediated first. Yep. And then I think what's going to happen and they do this in the Supreme Court, is you get a case management system.
Yes.
So you get one judge, whether it's family, small claims, all the way to the Supreme Court where your case managed. So you go in, you may have an interim hearing, but then you have a case management conference.
Yep.
And 9 times out of 10, you're sent out first to mediation. Then if that doesn't work, you're sent to either non-binding or binding arbitration. This is what they do in California.
Yeah, I was going to ask that question. Is this what they do in California? So that's
yes.
Yeah, that's great. Yep.
So what happened in the mid-'80s, they were seeing that. So the civil cases, as an example, the Code of Civil Procedure says there you have to try a case in 5 years, otherwise it's dismissed and it's time barred.
Wow.
The problem was the matters weren't getting to trial for 6 years. Right. So they had to create an exception. Then it was starting to be 7 years. So what they did is they had a reform committee like they have now for the family law, and they decided we need to have everything tried in 2 years.
Right.
Okay, so they wanted that big jump, even though more and more cases are being filed. So what they did is they went on this case management system. So you got one judge, and you had that judge through the whole matter. Right. From beginning to end. And so you got case managed every 3 months.
Yep.
You came in, where are you? Okay, mediation. Okay. Came in 3 months later, where are you? Okay, do you want binding or non-binding arbitration? You had to pick one or the other. Okay. Yep. You went out. Then you came back, and if you didn't resolve, so you're not about a year into it, 9 months, 10 months to a year, then they would set it for trial. But way they did it is in 3 months from then, and they, would set the deadlines for discovery and disclosure and all that, is they would have a settlement conference with 2 lawyers.
Right.
So 2 independent lawyers. As an example, I would volunteer as an independent lawyer, either in the civil or the family, to sit with another lawyer, each of them submit what they call settlement conference briefs.
Yep.
And the lawyer and I would look at it beforehand. We'd chat about it, and then we'd work to settle. And probably half to 60% of it settled in.
Okay.
Well, then what they did is the Friday, a week and a half before the Monday the trial was to go out, then they would go to a settlement judge.
Right.
Okay. So they were doing all these processes. Then usually on the day of trial, what would happen, that judge would have 5 matters to be tried.
Yep.
So what the judge would do is juggle and see if he could try to resolve any of those himself, getting permission to do that and try the case.
Yep.
So all of it was done in 2 years, less than 2 years.
Okay.
Yeah. So they fixed the system.
Yeah.
Yeah.
Well, that's
So they're
good.
going to have to do. Yeah, go on. Sorry.
I was going to say the same thing. Yeah, they've got to do something to fix the system, and that sounds like a good starting point of what they can do.
I think so. I think so. I think what's going to happen is mediations are going to become more prevalent. I noticed when I first moved into Australia in a standard commercial contract, there was no ADR clauses.
No, absolutely.
No, it was shocking
Mm.
because I used to do transactional matters, and that was standard.
Mm-hmm.
You always had an ADR. If you can't get along, you try mediation. If
Yep.
that doesn't work, then you go to binding arbitration through like the American Arbitration Association or something like that, or pick three and give you three, pick one, that kind of thing.
Yeah.
So they've got to do that here.
Yeah.
It's just, it costs too much money.
Yeah, absolutely.
Yeah.
Absolutely.
Yeah.
Well, that's excellent. So what about for you? What's next on the horizon for you personally?
I love what I do.
Okay.
So I'm going to keep mediating and I'm arbitrating.
Yep.
And I'm going to keep doing that. And we, go up to the Sunshine Coast as much as possible.
Yep.
Have fun.
Yep.
And watch sport. Yeah. Although I don't know about the bullets, but we can talk about that another time.
Yeah, let's leave that topic for a little while. Let's see when they come good.
Couple years.
Yeah, a couple of years.
Yes.
Unlike your Golden State Warriors. So they are.
Yeah, that's right. Those one, yes.
Yep.
And in fact, I made sure that I took off the time to watch the last series when
Excellent.
they played the Cavaliers.
Yeah.
So I used to have season tickets for them. So,
Right, yeah.
but they weren't good when I went and see them. So they get 2,000 to a game. Now they sell it every night.
Yeah, that's excellent.
Yes.
All right. Well, the final topic I just wanted to do was our quickfire question. So just 4 questions.
Sure.
Give me the quickfire answer. So you ready for that?
Sure.
Okay. So the first one is, how did you make your first dollar?
I mowed lawns.
Excellent.
No,
You know,
strike that. I sold Cub Scout cookies. That was even before mowing lawns. Okay.
In Ohio. Yeah.
In Ohio.
Yeah.
Yes.
Excellent. All right. Second question is, what book do you think that every business owner should read?
I like the 4 Agreements.
Yep. Great answer.
I would go with that.
Yeah.
There are all kinds of other books, Stephen Covey and
Yeah. The 4 Agreements. That's
that
a
would be
great
mine.
answer. Yep.
yes.
Great. And the final question is, if you could give advice to your younger self, what would that advice be?
Slow down, take your time, be mindful, enjoy it, because we're only here for a finite time. And, if I could have that back, if I knew then what I know now, isn't that what they say or something?
That's what they usually say. Yep.
Yes.
Yeah.
Just enjoy.
Enjoy your life.
There's too much fun to have.
Mhm.
Let's have as much joy as we can, and let's get rid of the conflict.
Yep.
Yes.
Great
So
answer.
that would be my best advice. Enjoy.
Excellent.
Yes.
Well, Farley, thank you so much for your time. But before I let you go, let me just ask you, is there anything that we've missed from our discussion today that you think is important?
Did you want to talk about costs? You had mentioned that.
Yeah, if you want to just mention the cost side of it. Yeah, that's fine.
And here's going to be your classic mediator answer. It depends.
I use that as the classic lawyer answer. It depends, because it does.
Yeah, it depends. It depends on one facts and circumstances. Yes. I'll give you an example for that that partnership dispute. For a day of that, it was $4,000 for a day.
Yeah.
And then $400 for each for the pre-mediation intakes, so $4,800 plus GST.
Yep.
Okay. A parenting matter is usually about $1,700 for pre-mediation intakes and 4-hour mediation.
Yep.
So it varies, and it varies on the complexity of the case. It varies on what parties can afford, because I try to, sometimes people can't afford it or they have to pay later. Yes.
Yeah. And I suppose the other factor is, if you are legally represented, you've got to pay the fees of the lawyers and the barristers if you've got them as well.
That's correct.
Yeah.
And I've had those, and then you're looking at a lawyer and a barrister, so you're looking at just them, at least $10,000 for the day.
Absolutely.
Before you pay me.
Yeah, that's right. That's right. Well, look, Farley, as I said, thank you so much for your time. Where can people reach you if they want to discuss anything further with you?
Okay, so I'll give you my number is 1-800-803-903, or if I can give my mobile, they can call me on my mobile.
Sure.
Because otherwise you may get somebody, you'll get my assistant. If you want to contact me directly, it's 0458 142 828 or farley.tolpen@mediationexperts.com.au.
Excellent. Well, we'll link those up in the show notes.
Okay.
So that people can see that if they've got anything. So yeah, thank you very much for your time, and we'll speak soon.
Jeremy, it's a pleasure. Thanks for organizing this. Take care.
Thank you.
Bye.
Well, I hope you enjoyed that interview with Farley Tolpen. As I said in the introduction, Farley's a really interesting guy. He's got a great history. And so the main three things that I hope you got out of that interview were Farley's take on the 4 agreements and going through those. And I think personally, and I said it during the interview, that the 4 agreements are really important, something that everyone should at least review and get an idea of. I really liked Farley's discussion about his process for mediation. I think the way that he goes about it really does show how he gets a 90% success rate in resolving mediations. And the final thing, what actually constitutes a good mediation and how the parties can prepare for it. I think those 3 things are really good. And so I really hope that you got that out of it. As always, check out the worksheet that we've prepared for this episode. If you're watching this on Facebook, it will be in the comments. I've put it up there. If you're listening to the podcast, then go to businesslegallifecycle.com.au/106 for the show. The show notes will be there, and the workbook will be there as well. So Craig, do you want to finish off?
Yeah, absolutely. Thanks everyone for joining us. As always, please get involved in the show. If you want to leave comments, ask questions or anything like that, we'd be happy to answer those where we can, and make sure that we're sharing information with our viewers and listeners that they want. If there's anything out there that they're particularly keen on hearing about, please let us know. Check out the website, get the show notes, and we'll see you next time. We'll be back again on Friday, I think, Jeremy, for the Legal Updater show, and then we'll be back after that for Fast Fix Monday and another long form show on Wednesday. So thanks everyone for joining us. We'll see you next time.
See you next time.